Welcome to the Pennsylvania Counsel Podcast.
Hey everyone, welcome into an all-new episode of the Pennsylvania Counsel Podcast with attorney James Creenan, the founder over at Creenan and Baskowski. I am your host, Mike Leon. You know, Jim has been representing business owners, professionals, contractors all across Western Pennsylvania in matters ranging from contracts, construction disputes, succession, and estate planning. Today's episode, we're going to be talking about how to choose between an LLC or an S Corp in the state of Pennsylvania, how it affects control, liability, and leverage once a business faces either a dispute, a debt, or an ownership change. Jim, it's good to see you. Happy New Year to you. Let me ask you here on the onset. So business owners, they come into you, they're trying to choose between an LLC, and an S Corp in the state of Pennsylvania. What are they usually trying to protect or control from your experience?
Hello again, Mike, and Happy New Year to you also. Thanks for having me back. I wanted to really tell you that our clients are looking for the most efficient way to handle their business overall, and that also would be an efficient bottom line. There are some misunderstandings that our clients would have walking in the door about the issuance of an S corporation. Take a look at this, Mike. There's two different laws in the land: the federal law, state law. Federal law would control how an entity is taxed under federal law. State law is going to allow for the creation of that entity. So under Pennsylvania law, we can choose a limited liability company, and then we have to make our federal tax designation. That often would be an S corporation, where we have individuals who are working in the business. And sometimes the other options available, aside from the S corporation for a limited liability company, would be a disregarded entity, but also a partnership taxation is available for limited liability companies too. Overall, our clients are looking for that kind of flexibility. They can achieve it with the limited liability company due to less restrictions, but they also get that benefit of the personal asset protection, which would control that only the limited liability company's assets would be at stake, provided that the company has operated correctly.
I mentioned in the intro about an ownership change, disagreements between owners. So from a legal standpoint, what actually changes with respect to an LLC or a corporation once there has been a serious disagreement amongst either owners or shareholders?
It's a good question. Most of the times when we see a change, we're going to look to the controlling document. That's going to be the limited liability company operating agreement or the company's shareholder agreement, or perhaps even bylaws. The limited liability company operating agreements generally are drafted in a way to give more flexibility to the members and to give a lot more clarity as to a way to get out of the limited liability company, if that's the desire of the partners who have come together to operate the business. Corporation has more formalities. The corporation laws are set up to be more strict and not as forgiving for small companies. So if we're talking about a company with less than $50 million in revenue, there's no reason for you to operate the same way as a company that is operated on the public stock exchange. You really want to make sure that you're tailoring what your agreements are to that, so that when you have a disagreement, you have an exit plan also built in. And that's not uncommon when we have companies that are striving to get started, but there's often a lot of struggles that sometimes our members or our clients do not understand from the outset.
And I'm assuming that entity choice would also affect, like you said about the agreement, would also affect who has the decision-making authority when the partners start disagreeing, or even if the business hits financial stress.
That's right. We want to look at, under the default under Pennsylvania law, the LLC would allow the members to participate evenly in the management of the company. The operating agreement can change that. That operating agreement and the associated documents that we would set out will identify who's going to be in charge as the manager, who's going to have that responsibility, so to speak, of the president of the company. That identification of responsibility and authority is one that's very critical, and that's the role oftentimes that has the responsibility to make the tough decisions over the matters that are in disagreement, aside from the big fundamental changes such as whether to stop the business or to sell the entire business or take other action.
Let's look at some other extenuating circumstances. Like, how about disputes that involve creditors, unpaid obligations? Excuse me. Like, how does the underlying entity structure then influence maybe exposure or leverage?
Yeah, of course, every situation is going to be different, but looking at the typical arrangement, a third party creditor without the presence of personal guarantees, generally is not going to be able to reach the personal assets of the individual members of the limited liability company. That's going to take a lot of extra effort for someone to go through that process and to achieve judicial recognition of any of their rights to receive any or to protect and execute on any claims. Where we have a difference in the corporations sometimes their assets likewise of a shareholder are protected, but they're not necessarily going to have the same protection under state law. So we like to look at the broader and tried and true at this point of all of the cases that have been decided under the LLC Act in Pennsylvania and in neighboring states to let our clients know that their investment in the company will be protected.
Speaking of investment in the company, what differences tend to matter most, especially when a business is adding, let's say, a new partner or maybe an investor, or maybe even like we've been talking about small businesses, a family member into the ownership mix?
Yeah, we have to look again at that operating agreement, and that's going to be the way to control who comes in the door as a member of the company. A member is identical in a lot of different ways to a shareholder of a corporation, but there's also oftentimes we place a little more restrictions in the limited liability company, and under the default laws, we do have more flexibility to provide for those protections for the company. Looking at our governing documents, we certainly have the right to restrict who will become a member and what would happen if an unpermitted or non-designated entity or person becomes a member of that company, such as the inability to receive distributions or the inability to participate in the control of the company. What we also want to look at is, how do we resolve those disputes? And again, our operating agreement for the LLC is going to define whether we need to have a pre-claim discussion, whether we need to have a mediation or arbitration, and do the types of things that we can help facilitate an agreement outside of the courthouse.
Jim, can you give us some examples, maybe in either direction, of where the entity structure itself made the dispute easier or much harder to resolve?
Yeah, I'd say we've had a handful of business partners that either early on or even after 5, 6, 7 years have decided that they no longer share the same vision. And when they no longer share that same vision, we want to have them have a way to clearly identify what's going to happen. Oftentimes, one person will say, I'm going to continue the business. I've put my time and effort in, and I'm going to do that. And we build in the operating agreement a way for that departing member to receive some compensation for what they've contributed, whether it be a return of capital, whether it be certain forms of payment, or even identification of receiving some intellectual property from the company, so that there's actual control and division over this process when people like to find and pursue new interests and talents without disrupting the overall operation of the business.
Jim, let me ask you about two specific industries. Like, let's go into like the construction industry, or maybe businesses that are like closely held. What entity related issues have you seen over your experience that tend to kind of surface once a project goes wrong on the construction side, or maybe a relationship breaks down?
Yeah, that's a good point. For the construction field, they have a much tougher job in a lot of ways. It's tough to run a construction company. You need a lot of talented people. You need capital. And what we oftentimes see is that when we have an absence of some of those success factors, we find the company will struggle and we need to look at what the operating agreement, if there is one, and what does that say, and what can the creditors do or not do. We want to make sure that we also have properly documented the manager and the members' participation in that company, so that we have the ability to ensure the client can take the benefit of the protections in the legislation for members of a limited liability company. That participation can be documented in the form of minutes, in resolutions, in other types of agreements, so that we have a clearer idea of how to protect company assets and perhaps even individual assets that have been contributed for the use or toward the dedication of the company's best interests.
Jim, as we wrap on today's episode, for that business owner that's listening to this and they formed an entity years ago, they haven't revisited it in a while. I know you're going to give a good recommendation there, but what kind of risks can kind of develop quietly over time if that structure no longer matches how the business is actually operating?
Yeah, the main one we see, and we see it a few times a year, would be a new client coming in. They've had a successful business. We start to look at things and we identify that they've never formed an entity, that they are what is deemed a sole proprietor. And the sole proprietor is probably the least advantageous operation when we're looking at succession planning, when we're looking at liability protection, and we're looking at all the things that we've been talking about on this podcast. So the key thing with the sole proprietor that people need to understand is that as soon as that sole proprietor passes away, then that business terminates under Pennsylvania law. That's a huge problem for the business owner's family and employees that they may have. So we really want to help them understand how to get started in a way that they can form an entity and transfer what they've been doing into that in a favorable way, using our talents and the talents of their tax professional.
Yeah. Jim, thanks for the time, the insights. I appreciate it as always.
Thank you again, Mike. Good to see you.
And that's it for today's episode, the Pennsylvania Counsel Podcast. If you want to learn more about Jim's work and the team over at Creenan and Baskowski, do me a favor right now, visit cbattorneys.com. Thank you again for listening. But before you go, hit like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. As always, I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.